Hello, everyone, and good afternoon. My name is John P.L.L.C. of P.L.L.C. Hauser in downtown West Palm Beach, Florida, and welcome to Technology and Ethics for the Florida Probate Lawyer, what estate planning attorneys and trust estate lawyers need to know. Okay. We're going to spend the next hour chatting about a technology requirement for Florida attorneys. The requirement is a continuing legal education requirement imposed by our Florida bar on the area of technology. This one CLE credit is also eligible for ethics credits, general credits, and certainly technology credits. And the reason we're talking about technology is mainly because of a new rule promulgated in 2017 by the Florida Bar for attorneys to receive a requirement to receive or obtain CLE credits in the area of technology. So for the next hour, we're going to be talking about instant messages, texting, iPads, tablets, cell phones, emails, computers, advertising, ethical rules, attorney's fees, costs, all of that, and technology, how that affects our practice and how we use technology for good or for ill today, and also some of the traps that we can experience. So here's our discussion outline for today's CLE. And by the way, this next hour is approved by the Florida Bar for 1 credit hours of continuing legal education. Florida Bar approved. You'll receive at the end of the seminar the course number so that at the completion of this, you can go onto the Florida Bar's website, self-report, and you'll get credit for the 1 hour that you've spent listening. We're also, P.L.L.C. Hauser, which is sponsoring this CLE, is live on Facebook. We're on Facebook Live right now and invite you to friend and like our Facebook page of P.L.L.C. Hauser. P.L.L.C. Hauser is a law firm in West Palm Beach, Florida that restricts its practice to disputes, trials, and appeals of probate, estate, trust, guardianship, and related issues. We don't prepare estate plans, write wills, or trusts. We do handle disputes, trials, and appeals in those areas. So our discussion outline today is we're going to be speaking a lot about Florida Bar Rule 6-10.3 when we talk about minimum continuing legal education standards and credits. And in addition to that, we're going to be talking about our ethical rules. And we're going to talk throughout the day about how technology affects our ethical obligations as attorneys and how technology runs afoul or can comply with our Florida ethical rules, and then we'll conclude. So by way of introduction, P.L.L.C. Hauser offers a number of CLEs free of charge online from time to time. For example, in 2017, we offered a number of continuing legal education courses for Florida lawyers in the areas of ethics, estate planning, malpractice, probate issues, and general litigation topics. We invite you to visit our website, phflorida.com, to look at our videos and to attend any number of CLEs that you can watch for free and which you can self-report and get credit for. In 2018, our law firm expects, by all accounts, to offer a number of other CLEs, including breaking cases, breaking news on the estate planning front. Certainly the tax bill that's in Congress right now will be the subject of a live CLE that we'll do in 2018, probably the first quarter, if not the first month or so, maybe February, depending on how fast Congress acts. And we're happy to bring that to you free of charge. If you have any questions about other CLEs, feel free to email amanda@phflorida.com. So by way of introduction, people say, you know, why are you giving a CLE for probate lawyers, and why are you talking about estate planning attorneys and what estate planning attorneys need to know? And the shorter answer is we don't handle estate planning. We handle litigation, but most of our colleagues do, right? Most colleagues are estate planning lawyers or probate lawyers or elder law attorneys in Florida, and they don't litigate, but we end up dealing with many of the issues that they and their clients and their families deal with. And right now in America, we're going through a massive wealth shift. $56 trillion is being passed from the World War II generation to the baby boomers and successive generations. Some of it's in the form of IRAs, beneficiary designations, bank accounts. Sometimes it's an irrevocable or living trust. Sometimes it's in an intestate estate where there is no will, and sometimes there's a will that's probated. And in this massive wealth shift, which is the largest in humankind, and the number, by the way, the $56 trillion, not billion, but trillion, that actually comes from the Boston College Center of Wealth and Philanthropy that has estimated the amount of that wealth shift. So you have this massive wealth shift going on right now, and it seems like everyone's fighting over inheritances, and it seems like everyone's objecting to trustees' work, right? Because everyone's using wills and irrevocable trusts or living trusts as part of their estate plan, and the revocable trust becomes irrevocable at the passing of the grantor, the client who created the trust. And many times money is left in trust, and sometimes trustees behave badly. Sometimes they do just fine, and they're also sued by beneficiaries. But clearly things have changed in the legal community over time. And so we're going to be dealing with some of the issues that we, lawyers at my law firm, encounter. Things that we see, markedly different than what most estate planning attorneys, elder law attorneys, and probate lawyers in general see, right? You folks are writing wills and trusts, you're drafting estate plans, you're dealing with family members. We see everything, usually when someone's passed away, right? The lawyers in our firm, though, increasingly, hey, for good or for ill, are getting involved in guardianship litigation, contested guardianships, where mom and dad or a senior family member or even an uncle or an aunt or even a neighbor sometimes are getting advanced in years, getting on in years, and frailties occur, right? We start breaking down, and our mind isn't as sharp. Even though our body and our physical attributes may be just fine, we may look great, but we may be ravaged by dementia or Parkinson's or Alzheimer's, rather, and we start to break down, and maybe somebody needs some protection, and that protection can often come in the form of an attorney, right? And so sometimes you need a guardianship, and you may or may not need a guardianship depending on how one's estate plan is prepared or drafted. But clearly guardianship litigation has really been on the rise, certainly over the last 10 years in Florida. And so those wills and trusts that you're writing are really, really important, but increasingly important are powers of attorney and healthcare advance directives, what some people call medical powers of attorney, or healthcare proxies. Those documents that make choices for a client when they're not able to, makes choices and decisions about their medical care. And I'm not just talking about a do not resuscitate order or a DNR. You know, we're talking about who you want to be your guardian if there's a guardian, whether you want to live in a persistent vegetative state or not, and who gets to make those healthcare and medical decisions for you if you're not capable of doing that, right? So who your successors are, really, really important. And well, a lot of time goes into choosing the personal representative or executor of your estate and the trustee of your irrevocable trust. We also need to recognize that because guardianships are increasing, even when you have an alternative to a guardianship, who you choose as your trustee, as your guardian, whether you choose a guardian, and who you're going to choose or select to make your healthcare decisions, amazingly important. Okay, long-winded introduction. Let's get into the meat of it, and let's start talking about Florida Bar Rule 6-10.3, the minimum continuing legal education standards. What is that? Why is that important? And what does that require you as a Florida lawyer to work on when you're in your office? Well, subsection B specifically addresses a minimum hourly requirement for CLEs, right? Continuing legal education. Each member of the Florida Bar must complete a minimum of 33 credit hours of approved continuing legal education activity every 3 years, right? That's the cycle. Every 3 years, you need 33 credit hours. Everybody seems to know that, right? Everyone seems to understand that. 5 of those, everyone seems to know, must be in approved legal ethics, professionalism, bias elimination, substance abuse, or mental illness awareness programs, right? So we all know generally, I think most lawyers think of, well, I need 5 credit hours every 3 years. But now also, 3 of those 33 credit hours must be in approved technology programs. And those technology programs must be included in, not in addition, or which are included in, not necessarily in addition to the regular 33 credit hour requirement. So you can't carry over any hours. If you get 40 in 1 year, you're not going to extend them into the next cycle. So 3 hours every 3 years on technology. That's what you need. And so our seminar today is all about technology and ethics. And if you need technology credit hours, this seminar will satisfy 1 credit hour in that regard. And my guess is we'll probably put on another technology seminar late in the first quarter of 2018, maybe early second quarter 2018. And we're really looking forward to doing a CLE on the tax bill that's coming down the pike from Congress that President Trump is expected to sign. Until then, for you probate lawyers, trust lawyers out there, if anybody would like a copy of my book, P.L.L.C's Trustees Guide, which is pictured on the screen, feel free to email Amanda at phflorida.com for a free copy. So 5 of the 33 credit hours must be approved in ethics and whatnot. There's a photograph of the new 4th District Court of Appeal that is being constructed down on Tamarind Avenue in downtown West Palm Beach, right across the street from the Tri-Rail station, down the hill from the federal court, and certainly down the hill and down the street from the main courthouse. So we see that 3 of the 33 credit hours must be approved. So let's go into our ethical rules now. And this is where we're going to be spending a lot of time. Everyone knows you need to be competent as an attorney, right? And God knows across the spectrum of lawyers in Florida, you would get lots of different definitions or interpretations of what competence means, right? Whether one is competent or not as an attorney, or whether the service is rendered as an attorney were competent or not. I think a lot of people would disagree. But so one of the purposes of this CLE today is to throw out questions for you, right? And so in that regard, the CLE ends up being probably one of the easiest, right? I mean, who wouldn't love a seminar where you just ask questions and you don't give anybody any answers? But we're going to try to give you some perspective and a little bit of guidance today. And I guess one of the first questions we're going to ask is technology now a component of competence, right? Are you required to be very comfortable with today's latest technologies, instant messages, texting, iPad, tablets, cell phones, emails, computers, Google searches, internet searches, background searches online, right? Is technology now a component of competence? And I think most people would say yes. I think a lot of people or a lot of courts might say, look how our practice has changed over the last 10 years. Very few law firms even have libraries anymore, right? Libraries with actual physical books take up space, and space costs money, either in the form of a lease or not putting a productive member of the firm in that space, instead if you're using it as a library. Conference rooms seem to be getting smaller, and there's fewer and fewer books in what used to be the library. But increasingly, people are using online services to do their research. I know at our firm, Pinkowski Hauser, we do virtually all of our research online now, right? Even though I was trained as an attorney in the 80s and 90s to do research with books, right? And you shepherdized cases, and you looked at 3 or 4 different inserts or books or newspaper printed editions to find out if a case had been cited or overruled in the most recent time period. And that all seems to have gone away, right? Remember when you used to go to like the law library in Palm Beach County at the main courthouse and pick up those big blue West books, and you would do searches in the index for the topics that you were studying on, and then you would go to another book that had all these cases divided and distributed by topic now. That seems to be all gone if people have computers, right? Because people are using online searches and proprietary search engines and web-based research tools, right, to do your research, your cases, administrative rulings, and to some degree trial court rulings, right? Unpublished opinions, quote unquote, unpublished. So I think that technology, or the use of technology, certainly has become a component of competency today. But beyond there being no more libraries and most of us conducting research online or through proprietary research sites, I mean, you know, think about saving data and think about saving the file, right? I don't think anyone's gone entirely paperless. But in our firm, right here, where we have a small probate litigation practice, there's maybe 8 employees full-time. When we were down the street at our smaller office, we actually used to have the binders with all the court file documents for every single case, and we had lots and lots of papers. And our support staff and paralegals would save online the court file document, like a pleading or a petition or a response or a motion and an order, and we would keep them on our drive, our computer drive, and then we'd print a copy and we'd put it in the binder. And you could go up and pick up the binder of the court file documents. We don't do that anymore, right? And I remember going into the office on a Saturday when no one else was there, picking up a binder and saying, hey, where's that motion that was filed? Why isn't it in here? And I remember our firm administrator, Dana Murray, talking to me about going paperless. We don't need those binders anymore. And I said, no, I don't think we're ready to do that yet. And sure enough, over time, I noticed, without telling her to get rid of the binders, when I was looking for a court file document, I stopped walking over to the filing cabinets where the binders containing the court file documents were located. I was looking online on our computer. And for our computer, right, we have what we call the Z drive. The Z drive is our master file where we keep all our clients broken down by last name. And on each client, we have communications with every person that we communicate with. We generally save all emails now, right? Are you saving all your emails as PDFs and saving them on your Z drive, your hard drive, right? Your computer drive, or are you printing off communications, punching 2 holes in them and putting them in a folder? Think about how your practice has changed just in the last 10 years and how technology has made us act differently and save our clients' data so differently, right? And when we're talking about saving data, how are you saving it? Do you have a server in your firm? Is that server somehow backed up? Is that server secured from break-in or a hurricane? Or do you save your data in the clouds and it's saved in some master mainframe or master server somewhere in some warehouse, right? Or on some satellite hovering above the earth? How do you save your data? Competence. I think you need to be competent at a threshold or basic level in technology just to practice law, right? We all have e-filing and e-serving now, right? There's a portal where you can send documents to, where you must send documents to. So you need to know how to e-file. You need to know how to e-serve. 2 short notes about competence and how we practice law before we move on. 1, the fax machine. Our firm administrator, about maybe 7 years ago, maybe 6, could be more, said, John, let's get rid of the fax machine. We don't need a fax machine anymore. Well, why not? Well, John, we scan documents all the time. I said, no, you know, somebody might not scan. Let's keep the fax machine. We ended up getting rid of it within 6 months. No one was sending faxes to us anymore. Everybody was scanning. Everybody was saving PDFs, emailing documents to everybody. The fax machine to us had become obsolete. I'm actually floored that people are still using fax machines. We now have the ability to scan all our documents, and it's admittedly easy. We use Canon printers, laser printers that are 3-in-1. They can scan, they can print, they can copy. But most of us have a little more expensive, a $500 Fujitsu ScanSnap that scans documents very, very quickly. The program's easy to use. And so what used to be once purely a secretarial or administerial task, like making a copy now, is something that associates and partners can multitask on, right? I can review an email at the same time, or talk to my client at the same time that I put a document into our scanner and create a PDF. And so I'm saving documents in one stop very quickly. I can email it to my client, and I can save it on our Z drive where it should be saved forever. No copying, no binders with court file documents, no physical paper files with communications with clients or anybody. That's all changed. That's all on a computer now. Diligence. Rule 4-1.3. As lawyers, we must be diligent, right? We need to be communicating with our clients. We must take action in a reasonable manner. We must respond appropriately and within a reasonable time frame. And that doesn't mean that we necessarily need to do anything immediately, right? Diligence isn't always immediately, although immediacy may be one element under certain circumstances. But we do need to respond, right? When clients who are trust beneficiaries call up my firm and talk to us about suing a trustee or their displeasure with their trust or their trustees, we end up explaining to them about trustees and a trustee's duty under the Florida Trust Code to provide relevant information. And what we generally say is that, look, your trustee should be communicating with you and your trustee should be sharing information with you. After all, a trustee can't hide the ball or operate a trust in secret or private. Right? A trustee has a fiduciary duty to their beneficiaries, and this specifically includes sharing relevant information. But a trustee isn't required to be knee-jerk. You should respond to your beneficiary's inquiry, but it doesn't necessarily need to be that day or the next day. How does technology affect our duty of diligence? Emails, texting, U.S. mail. Are people still using the U.S. mail? I got a call from a lawyer the other day who said, hey, I'm going to sum up our cases and send you a settlement proposal. I'm going to outline some issues for you. And I said, that's great. Let's chat about it and see if we can bring everyone together. He sent it by the U.S. mail. And I remember getting it about a week later. And I thought to myself, who sends anything by the U.S. mail anymore? He could have emailed the entire document in PDF format to me, and he didn't. I just remember thinking, that makes no sense. That took a week for me to get here. He could have sent it to me in a minute by email. Are you using email to communicate with your clients? Are you responding to them? Isn't that one of the problems that we face? You walk through restaurants, even in court, everyone's on their cell phone, right? We're glued to our phones now, which are mini computers with watches and compasses and internet access and music and cameras and emails and documents, right? And directions and maps. We're all glued to them. But emailing us, to me, is almost first nature now, right? We're all doing that. There's very few things we send out by U.S. mail. One of the big exceptions in the probate world is formal notice, right? We send out documents with a return receipt. Sometimes we send that by FedEx or UPS overnight. But increasingly, email is the mode to communicate with everybody. Settlement agreements, communications to clients. And generally, when we get court file documents through the portal or an order from the judge or a motion or something, you simply forward it to your client. And so everybody's getting everything so much sooner these days. Some of you text with your clients. I find texting and email to be absolutely amazing for convenience, not necessarily great for conversation and communication. But people are now texting with their clients rather than using the U.S. mail. And as far as being a competent attorney and at the same time being diligent, we need to be careful, right? Because we don't want to send a text message by accident to the wrong person. Send a text message to a client that was intended for somebody else. Or God forbid, send a text message to a non-client when we think that person's a client. So we need to be diligent. We need to be reasonably prompt. And with technology, we also need to be careful. One of the frustrating things I think that lawyers experience with technology is that sometimes clients or prospective clients may want us to be very fast in our responses, amazingly responsive over a much shorter period of time. In some cases, almost instantaneously responsive. So we need to be careful about that. The immediacy and the urgencies of legal issues does not necessarily require us to answer emails and answer text messages after business hours, on weekends, or at nights. And that's a real challenge for a lot of lawyers, right? And sometimes for clients too, because clients want to know that they can get in touch with their lawyer. And so I think one of the things from a diligence issue and a technology issue that we as lawyers struggle with is, when do we put down the iPhone, or when do we put down the emails, or what do we do? Should we correspond with our clients at night? Are they expecting us to? What about weekends? God knows many of us work weekends. But is it necessary? The other side of that legal coin is, how difficult is it to forward an email that you may have read after hours, on weekends, at night, on a Sunday, to a client or somebody else that you've just received? Fees and costs. Rule 4-1.5, a topic that is very near and dear to a lot of you probate lawyers. Why? Because in the probate and estate context, there are fee statutes, and many times you're going in front of a court and asking them to approve your fees. And for good or for ill, lawyers' fees and costs reimbursement motions have come under increasing scrutiny, not just from clients, but trust beneficiaries, estate beneficiaries, and indeed courts, right? Judges. In Palm Beach County, I think the judges do a good job of really trying to bend over backwards and looking out at how much is being spent, particularly in the context of an estate or a guardianship, where you're spending someone's monies, either the wards or maybe a beneficiary's inheritance. Fees and costs. How do we look at fees and costs? Are you spending a lot of costs on couriers and overnight deliveries? And is it necessary? Couldn't you just email the stuff? It gets there quicker and it really doesn't cost any money. Your technology. Is your technology like your proprietary research, your search engines? Is that something that you can pass on to clients? And if so, how do you track that, right? How do you track that? So Rule 4-1.5 is a rule that many of you probate lawyers will recognize, right? Fees and costs for legal services. And we're going to talk about that for a while. But I'm amazed at the number of attorneys who go into a judge, go into a probate court seeking to get their fees and costs and either do not know how to handle a contested fee motion or just assume that the judge is going to approve everything. And my experience is that many of those fee hearings are contested. And so you need to know how to conduct yourself in a fee hearing. You need to know what a proposed order should say, all right, because our appellate courts have said consistently what a proper order on attorney's fees is, what the components of an order are needed to have a proper order, and also whether you get fees through an order on entitlement or for litigating the amount of fees. So fees are really important to you because many times you're getting them from a trust or an estate and a court needs to pass on them. And we need to know how to deal with those fee contests and those fee hearings when we're presented with that. Now, we know that we can't charge clearly excessive fees, right? We know that. Yet within one practice area, you can see a huge swing by over 50% of the fees that are customarily charged by lawyers in a particular geography, right? One probate lawyer might charge $300 an hour, and another one might charge $600, let alone $450. So we have to look at the factors to be considered in determining reasonable fees and costs. In our practice, when we're representing a lawyer to help him or her get their fees and costs in a contested matter, or we're representing a trustee or a personal representative, maybe we're representing a beneficiary who's objecting to fees and costs. Some judges will permit you to submit a proposed order, typically in Word format, by email. Others do not. Some judicial assistants regularly communicate with attorneys. Others do not. Some divisions have online booking or scheduling of hearings. Others do not, right? We do it the old-fashioned way. We call up the judicial assistant. We try to get prospective times for hearings. Then we start circulating that by email amongst the lawyers in the case. And if we agree, we call the judicial assistant back up, hoping that one of those times is still available, and then we book it. The factors to be considered in determining reasonable fees and costs are on your screen in front of you. And when I draft an order on my computer, I'm trying to list all those factors. And I was just at a a very big fee hearing, very big six-figure fee hearing in North County. And the judge came right out and said, and she was wonderful, and she was very upfront about it. She says, raise your right hands. I want testimony. I want you to go through every row factor. I want you to go through every factor in 4-1.5. And we were prepared for that. Indeed, we expected that. Other lawyers were floored that they would have to actually go through the rules that regulate our conduct and our fees and explain that to a judge. But as litigators, we're used to that. And when we prepare an order for a judge to consider, or for the other side to consider, we want to make sure it's appellate proof to the extent we can, right? We want to list, we want to present evidence to the court so that the court can make findings of fact and conclusions of law, rulings of law. And we want that all evidenced or reflected in an order. We want to get it right. And so we try to provide testimony and documentary evidence to all the factors that are found in 4-1.5. Right? Because in considering what are reasonable fees, you've got to consider a number of factors, including the time devoted, customary rate in that area, a number of controlling factors. But what some lawyers refer to as the row factors, and on your screen are the two most cited cases for attorney's fees factors: Florida Patients Compensation Fund v. Roe, 472 Southern 2nd, 1145, and Standard Guarantee Insurance Company v. Quanstrom, 555 Southern 2nd, 828. Right, so those are two of the cases we typically cite in an order, as well as any applicable contract or contractual provision, as well as any particular statute, particularly in the case of 744, the Guardianship Code, 736, the Florida Trust Code, or the Probate Code. Right? And you want that legal authority in your order that you're typing up on your computer before you're going to the hearing, or that you're sending to the court soon after your attorney's fee hearing. One note about attorney's fees and costs. Just the other day, I got an email talking about technology. I got an email from an attorney in New Orleans who said he represents an heir of a very famous athlete who passed in Florida, and he's looking to retain counsel in Florida for what was expected to be an estate dispute. And this wonderful, very, very intelligent attorney asked me about referral fees and fee sharing. And in Florida, we are prohibited from sharing any fees with non-lawyers, whether they're paralegals or people outside the firm. And according to our rules, a great, really good, intelligent lawyer from any other state who is not admitted in Florida is a non-lawyer. So no fee sharing with non-lawyers, period. The reason he found me by kind of coincidence, well, I don't know, it was coincidence, but it was a Google search. He did a Google search for a Florida probate lawyer and somehow got in touch with me. So technology is affecting the way we get clients now, and what our fees are, and we need to know how we can charge and who we can share our fees with and who we can't. On the screen, you see a slide about the enforceability of fee contracts. It is a best practice to have the scope of your representation, your fees, your charges, what you're going to do and not going to do in a written contract with the client. In our firm, it's standard practice that we generally do not begin work until we have a signed fee contract received by the firm from our prospective client. And so many of you still don't do that. You don't have fee contracts. And clearly it's a best practice to do that. Earlier in 2017, we had a CLE on estate planning malpractice where we discussed all about legal malpractice and some of the issues that heirs and beneficiaries and lawyers, our friends, colleagues, estate planning lawyers, probate lawyers face in their practice and potential dangers, right? Potential liability. And we talked a lot about having a written contract and the importance of having a written contract and communicating with clients and updating clients. And so you see the enforceability of fee contracts on your screen, because clients sometimes do get upset with your bills, right? Sometimes they are just taken aback by what you charge. And so in that regards, communication is really one of the best keys. And I find that the duty to communicate not only your rates and what you're going to charge to your client from the outset, such as in a contract, but on an ongoing basis. So one of the best practices that one could have when you're sending invoices to clients is to say, attached is invoice number 1234 for the month of July in the amount of $4,000. Please note, you have now spent $34,000 on your legal matter, reminding the client of how much they've spent on their legal matter. Now, I know a lot of you listening are cringing at that. You would never want to do that. But I think that running away from what you're charging or the expense of what you're charging is not necessarily a good practice. As young attorneys, I think many of us were very concerned about not losing clients and not scaring away clients, right? Particularly if you really wanted the case. But I've grown now to really be politely upfront about that legal fees are expensive, and the rates that we charge are very healthy. It's not inexpensive to hire a lawyer, let alone a litigator. And that is a factor that all clients must consider, certainly when hiring a lawyer or going down the path of litigation. And I think being upfront about that is the right way to go. And I think reminding a client how much they've spent along the way is also insightful. A duty to communicate, not only a duty that helps the client, but also helps the lawyer, perhaps. Contingent fees, I won't get into. God knows there's a whole section of lawyers out there who take cases on contingency fees. But confidentiality is something that we do need to talk about. Rule 4-1.6, our duty of confidentiality to and for our clients. A number of issues on technology and confidentiality. Do you text with your clients? Do you send emails to somebody who is not your client? How many times has a prospective client called you up and said, yeah, I'm calling for my spouse, but he wants you to talk to me. I don't do email, but send it to my spouse, right? How does technology affect your confidentiality? Well, I think most litigators would say, how does technology affect the attorney-client privilege, right? A best practice is to tell somebody, I need to send confidential communications to you and only to you. Get an email that is not one that's used at work, that is a private email, that is not your spouse's or anyone else's, and one that no one has access to. And if you don't have one, go get one. Go to Yahoo, go to Gmail, but get one. Because that's our primary way about how we're going to communicate. In fact, in our legal services contracts now, we say we're going to send you invoices by email. We also tell them that you have 30 days to object. Why 30 days is a fourth DCA case that says 30 days is not unreasonable. So confidentiality, emails, make sure you're emailing just your client. If you have multiple clients, there's a concern that they're going to email each other, and you should consider whether a joint defense agreement is appropriate when you have multiple clients. Another best practice for technology and ethics is to send a client an email or a communication at the onset of representation, reminding them that they shouldn't post on social media such as Facebook or Instagram or anything else, because what they post can be used against them. You can remind them not to communicate with those they're suing or those who may be involved in the case or who may be adverse to them or who may be aligned with people you're adverse to. Right? That it's best left to have the lawyers communicate with their lawyers. A reminder that says, don't tell anyone what you talk to your lawyers about, and don't forward any documents or things that your lawyers send to you. A reminder and an explanation of what the attorney-client privilege is and how confidentiality may be maintained, or how the attorney-client privilege can be mistakenly broken. From our standpoint, we need to be careful about texting and emailing to make sure we don't divulge confidential information to non-clients. Conflicts of interest, Rule 4-1.7 deals with conflicts of interest with current clients. And you see the rule in front of you. It talks about a significant risk that one or more of the clients will be that the representation will be materially limited. We can't be adverse to a client. We know that, right? We can't represent someone on a Monday, sue them on a Tuesday, but we also have to be mindful that the representation of another client might materially limit our ability to help another client. And that we can't do, right? We can't serve multiple masters. We can't serve clients who have conflicting interests. Now, there's an exception, a carve out, and you see that in section B on the screen. There are also potentials for conflicts with others and prohibited transactions with others. That's Rule 4-1.8. Generally, we're talking about a business transaction, and you certainly can't use information to the disadvantage of a client, right? Information you receive, and with technology today, information is being thrown at us, right? You go on Facebook to catch up with your friends, and there's news now, and there's ads, and friends of friends are liking friends of friends, and all this stuff is popping up. And I can't tell you, when we're looking for a defendant or we're looking for someone who's committed financial exploitation or conversion or financial abuse against the elderly, we look on Facebook. We're looking on the internet to find out where these people are and where the money may have gone. So be mindful of that, and be mindful of the conflicts that are out there. When a celebrity passes in America, and in 2017, we lost some giants, right? We lost Prince, we lost Tom Petty, we lost a number of other artists and people. they have literary rights, copyrights, intellectual property rights, and other media rights. And it seems like everybody has a book deal, or a made-for-TV movie. So you need to be very cautious about acquiring literary or media rights during ongoing representation. And you'll see, if you scroll down to paragraph 4 on the screen in front of you, an issue that I raised previously about the good lawyer out of state who found me on the internet, contacted me by email, and was a non-Florida lawyer, right? And that was when I discussed that we cannot share fees or compensation with non-lawyers. And in paragraph X, understand that, particularly in the family context, right, whether you're divorce or probate, estate, or trust, there may be a senior family member or somebody else who offers to pay your client's legal bills. Generally, your lawyer shall not accept compensation for representing a client from one other than the client unless the client gives informed consent, right? And so that's important. If somebody's going to pay you who's not your client, the client needs to approve that, and they should do so in writing, right? And they should understand that. And then as a lawyer, you should understand who your duties are towards. Your duties are toward your client, but are you going to share invoices with the person that's going to pay your bills? And are you going to redact those invoices or not? With technology, it's easier than ever before to redact invoices, right? You can go to a PDF or a Reader or an Adobe program, and you can make these redacted invoices or documents look really, really pretty, right? Really, really good. And today you need those type of programs and that type of technology. Why? Because when we file court documents, particularly in estate proceedings, we used to list people's social security numbers and financial bank account numbers, and now we have to block out those numbers except for the last 4 digits. So you need that technology, you need that ability to deal with local administrative rules and the rules which regulate our conduct. Finally, on your screen, paragraph F, just be mindful. Unlike other service providers, we cannot have an agreement limiting our prospective liability, right? You see that a lot in accounting, some architectural, even some construction contracts that say, hey, the limit of my liability for the services that I provide to you are limited to the fee that you pay me. Lawyers can't do that. There's a good way to get around that, right? When I review those contracts for clients or for myself, I think that's silly, and I tell them that, and I think it's unfair. If I hire a service provider who I spend $5,000 on, but they make $1 million mistake, well, that isn't right. Their liability shouldn't be limited to the $5,000. That's what they should carry insurance for, right? We all carry insurance. And it not only gives us a little peace of mind and protection, but it should give our clients peace of mind and protection, right? And I do that, and I expect service providers, which I hire, to do the same. To me, that's an easy argument to make. Conflicts with former clients. We have duties to former clients. You can check that out. I'm amazed at the number of probate lawyers who send client files to non-clients. I think one of the biggest mistakes out there from an ethical standpoint that estate planning lawyers make is sending a client's file to non-client family members, where a son or a daughter calls up and says, Mom or Dad's incompetent, we got a guardianship case going over, send me the estate planning file, and the lawyer does it without that family member, non-client, demonstrating that they're court-appointed guardian or something. Floors me. Be mindful of the duties that you have to clients and former clients. Talk about imputation of conflict of duty, disqualification of law firms. You see the rules that are in front of you. Also representing entities, companies, and organizations. I know a lot of you estate lawyers out there. You'll represent a lot of family partnerships, LLCs, and even businesses. And so your duties for an organization versus an officer versus a shareholder, member, or partner are different. That you see a picture of the main courthouse for the 15th Judicial Circuit in downtown West Palm Beach, just a few blocks from our office at 415 South Olive Avenue. Prospective clients, you absolutely have duties to them, even if they don't hire you, right? So we get calls every week from prospective clients who may have found us through another lawyer, and maybe they email us, or maybe they call us, or maybe they somehow reach out to us. The best practice is to have a very rigorous intake procedure where a person who's articulate, intelligent, has got a great background, is the first person to speak with the prospective client so they can conduct a conflict check. Can't tell you how many times people call up and say, I don't want to tell you who's involved. And we tell them politely, we can't speak with you. I can't have a conversation with you. You don't tell me who's involved. Because what if you're adverse to an existing or a former client? Can't do it. We know under our rules that if a person contacts you as a prospective client and shares confidential information with you, that you can't use that against that client or that prospective client, even when they don't hire you. And so as a standard, when we agree to speak to a prospective client, when we've determined there's no conflict, we're upfront with them and say, look, we'll speak with you free on the phone. We usually limit it to a certain amount of time. And we tell them, look, the initial consultation is free. There's no charge. There's certainly no obligation to hire us. And what you tell us is confidential. So even if you don't hire us, it's okay. We're not going to go work on the case for anybody else. Having some type of practice, some type of standard for your intake, very, very important. Our final stage to prospective clients and the duties that we owe them is we, as a best practice at our firm, try to send out what we call a no-rep email, where we're using technology to communicate with these prospective clients. And if they haven't hired us, we try to send each and every one of them a very polite email that says, hey, thanks for speaking with us. We're flattered you did. I'm just writing to confirm you haven't hired us. You're not a client, we're not your lawyers, and nobody at our firm is doing any work for you. We send this merely to avoid any confusion, right? Because lawyers, the last thing that we want is for someone to think they're a client, we're doing work for them, and we're not. Technology, let's wind up this CLE. Emails, are you saving all your emails? Are you saving all your communications with your clients? Do you have self-deleting mechanisms on your email system? Are you getting emails in discovery? Are you asking for emails in discovery? I know some of your probate lawyers are floored when we send out discovery, and you wonder whether you can conduct discovery in probates. The truth is that the Florida probate rules, as well as our rules of civil procedure, certainly permit discovery in probate proceedings. So if you're hit with a subpoena, right, you know, or a letter or a communication that says, I'm going to subpoena your records. I'm telling you right now, preserve all evidence. Suspend any self-deleting mechanisms. Are you doing that? Do you have a method to do that? And then finally, what about inspecting documents in computers, right? Generally speaking, people have an opportunity to independently verify whether certain data is complete and accurate or not. And increasingly, right, e-discovery is a subspecialty within the legal world now. And so increasingly, lawyers are saying, I want John's computer inspected, or I want to independently verify that those are all the emails that so-and-so produced. Before you agree to that, consider that there should be some reasonable parameters or conditions or restrictions to the use of that technology, or that service provider is going to come in and review your computer or your hard drive. Who chooses that person? Who's going to oversee that person? How long is it going to last? How long is that going? Who's going to pay for that? How much is that going to cost? generally you want to pick your own person to do that, preferably somebody with the experience and knowledge of your system, right? And you need to be extremely cautious because you have a duty of confidentiality. And if your computer is being inspected, you don't want somebody reviewing other clients' information. What steps are you taking to protect the confidentiality of your other clients? How are you dealing with your texting and your duties of confidentiality? Are you discovering these text messages? We've had cases and trials where text messages were absolutely reproduced and used as evidence. If you're on social media, don't talk about your legal matters. Don't talk about people you may or may not be adverse to. In fact, you may just want to shut down that account, particularly if you're going to be testifying or your character is called into question. Photographs and images, the issue these days seems to be what's an original and what's not an original. And do you know how to get a photograph or a reproduction into evidence? Website, a lot of rules about solicitation and advertising that need to be followed. Everybody seems to have a website. And I think more and more lawyers would tell you that people are Googling you and checking you out before they're meeting you. I'll never forget the case that I had years ago where I met with a prospective client. The referring attorney was on the line. We were all in a conference room, and he started to tell this prospective client about my background, and she interrupted him and said, "Oh no, I've already Googled him." And that's the first time that ever happened years ago. And I was shocked that people were looking me up on the internet, and I realized, wow, there's more out there than we perhaps realize. Be mindful when a client's spouse calls you. We recognize that some marriages are very close and very long lasting, but a non-client spouse is a non-client. You can't talk to your client's non-client spouse about your client's case. Be mindful of that. Be mindful when a client or a prospective client shows up with an advisor and wants to sit in on an attorney-client meeting. Kick the advisor out because you don't want that attorney-client privilege broken. We talked about joint representation and joint defense agreements. So today's course number is 1707. 176, N as in Nancy. The course name is Technology and Ethics for the Florida Probate Lawyer. My name is John Pinkowski. If we can assist with any trials, disputes, and appeals involving wills, trusts, estates, probates, or guardianships, by all means, please give us a call at 561-514-0900, extension 101, or feel free to email amanda@phflorida.com. It was a pleasure speaking to you about technology and ethics for the Florida Probate Lawyer. We invite you to attend other Pinkowski-Hauser-sponsored continuing legal education courses for Florida attorneys, and invite you to check our website, phflorida.com, for other videos and CLEs that are already available free of charge. Thank you for listening.